generating the profit continuously. Okay, there are some liabilities that you are paying off. Hello students and welcome to another lecture, and the topic of this lecture is Comprehensive Guide to the Sarfaesi Act. Okay, so हम बहुत सारे judgments, बहुत सारे legal developments पढ़ते हैं in the field of commercial litigation, commercial law, क्योंकि ये बहुत तेजी से grow करने वाला sector है और इसकी जो डेवलपिंग सेक्टर की जो नेचर है उसको समझने के लिए इट इज इम्पॉर्टेंट फॉर अस टू हैव एटलीस्ट मिनिमल आइडिया अबाउट laws such as Sarfaesi Act, because like for example, if we talk about arbitration, or if we talk about company law, or if we talk about non-banking financial institutions, or if we talk about non-performing assets, and if some of landmark judgments that are actually coming from the top court of the country, it comes before us. So it will be really difficult for us to comprehend it if we do not have a good idea about, or at least a minimal idea about laws, commercial laws such as Sarfaesi Act. So this act is one of those commercial laws which we are talking about, that commercial litigation is based upon. So let us begin this lecture. Comprehensive Guide to the Sarfaesi Act 2002, Key Provisions, Processes and Impact on NPA's Recovery. How do banks and how do financial institutions, they depend upon this law for the recovery of non-performing assets, and what is the process, what are the key provisions? That is very important, because the landmark judgments, they keep coming in. When I go through the judgments, I really, the question that agitates my mind is that how am I going to explain you a thing which you do not have any idea about? So it is better for us to at least have a good idea about this topic. The Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, Sarfaesi Act. This is the full form of this abbreviation. The Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, Sarfaesi Act, stands as important legislative measures that aims to address the issue of non-performing assets in the banking and financial sector. This act provides a legal framework for banks and financial institutions to recover dues from defaulting borrowers through the enforcement of security interests. So this act provides a legal framework. There is a legal framework. There are some provisions. They provide for banks and financial institutions to recover dues from defaulting borrowers through the enforcement of security interest. भाई एक इंसान जो है फॉर एग्जाम्पल बैंक से लोन लेता है लेकिन वो डिफॉल्टर हो जाता है, तो कैसे रिकवर किया जाएगा? सिक्योरिटी इंटरेस्ट. अब आपने फॉर एग्जांपल मॉर्टगेज कर रखी है अपनी प्रॉपर्टी, ठीक है, जब आप इमूवेबल प्रॉपर्टी गिरवी रखते हैं तो वो मॉर्टगेज कहलाती है, और जब आप मूवेबल प्रॉपर्टी गिरवी रखते हैं तो वो पॉनिंग कहलाती है, PAWN, पॉन. ठीक है. सो this act provides a legal framework for banks and financial institutions to recover dues from defaulting borrowers through the enforcement of security interest. See, पुराने जमाने में क्या होता था कि मनी लेंडर्स होते थे. यू मस्ट हैव रेड शेक्सपियर्स वेरी famous novel in which there was a character Shylock. Okay, so Merchant of Venice. In that Merchant of Venice, Shylock was a money lender. It was a Jew money lender, and he used to lend money on a very high rate of interest. And you know the kind of character that is shown, that is shown or predicted in that novel of Shylock, that is actually the reality of the money lenders. If you even visit rural areas and if you talk about, अब तो इतना नहीं होता है, लेकिन पहले जमाने में क्या होता था कि रूरल एरियाज में लोगों के बैंक्स से लोन लेने का कॉन्सेप्ट नहीं था. तो मनी लेंडर्स दे यूज टू एक्सप्लॉइट द बोरोवर्स टू अ ग्रेट एक्सटेंट, बहुत ज्यादा एक्सप्लॉइटेशन होता था। तो इसको रोकने के लिए एक पूरा फ्रेमवर्क तैयार किया गया है सरफेसाई एक्ट में कि किस तरीके से आप रिकवर कर सकते हैं, व्हाट आर द टाइम लिमिट्स, क्या क्या हो सकता है क्या नहीं हो सकता, वो सारी बातें यहां पर सिक्योरिटी इंटरेस्ट से और रिकवरी से रिलेटेड मेंशन्ड है। दिस आर्टिकल कंटेन्स वेरियस एस्पेक्ट्स ऑफ द सरफेसाई एक्ट इंक्लूडिंग इट्स ऑब्जेक्टिव्स, मैकेनिज्म्स, प्रोसेसेस एंड implications. Okay, objectives. Banks and financial institutions faced difficulties in recovering their dues, which adversely affected their profitability and operational efficiency. To address these challenges, the Surface Eye Act was introduced by the Indian Parliament with the following objectives. See, ये प्रॉब्लम क्या आ रही थी, ऑब्जेक्टिव्स क्या था? देखिए, कोई भी लॉ आर्टिकल 14 में भी सबसे इंपॉर्टेंट एस्पेक्ट होता है कि लॉ जो है वो किसी ऑब्जेक्ट के थ्रू बनाया जाए, किसी ऑब्जेक्ट को सामने रखते हुए बनाया जाए। आप ऐसा नहीं कर सकते कि आपके मन आया, आप लेजिस्लेचर में बैठे हुए हैं, आपका मन आया, आपका मूड हुआ तो आपने लॉ बना दिया किसी भी चीज पे, नहीं। यू एवरी लॉ मस्ट हैव एन ऑब्जेक्टिव। विदाउट एन ऑब्जेक्ट वो लॉ बिल्कुल बेकार हो जाएगा, ठीक है। तो ऑब्जेक्टिव क्या था इसका? बैंक्स एंड फाइनेंशियल इंस्टीट्यूशंस दे फेस डिफिकल्टीज इन रिकवरिंग देयर ड्यूज व्हिच एडवर्सली अफेक्टेड देयर प्रॉफिटेबिलिटी एंड ऑपरेशनल एफिशिएंसी। चाहे पब्लिक सेक्टर बैंक्स हो चाहे प्राइवेट सेक्टर बैंक्स हो, बड़ी प्रॉब्लम आती थी उनको कि वो रिकवर कर सकें अपने ड्यूज, और उनकी प्रॉफिटेबिलिटी खत्म हो जाती थी। आप सोचिए, कई करोड़ रुपए, फॉर एग्जाम्पल कई करोड़ रुपए उन्होंने लोन दे रखा है। अब उन्होंने अगर लोन दे रखा हो, वो रिकवर नहीं कर पाए, तो सोचिए उनके कितना जबरदस्त फाइनेंशियल लॉस होगा। अच्छा, अगर बैंक्स को फाइनेंशियल लॉस होगा या कंट्री के फाइनेंशियल इंस्टीट्यूशंस को फाइनेंशियल लॉस हो जाएगा इतना ज्यादा, तो फिर आप सोचिए कि इकोनॉमी को कितना बड़ा सेटबैक होगा। तो ये एक खाली एक फाइनेंशियल इंस्टीट्यूशन की भलाई के लिए नहीं, बल्कि लार्जर इंटरेस्ट में पूरी इकोनॉमी को सेफगार्ड करने के लिए ये लॉज बनाए गए हैं विद दिस ऑब्जेक्टिव। To address these challenges, the Surface Eye Act was introduced by the Indian Parliament with the following objectives. This point says that the Act provides banks and financial institutions with a streamlined process for recovery of loans and enforcement of security interest. एक पूरा process of law, due process of law, establish किया गया है जिससे बैंक्स और फाइनेंशियल इंस्टीट्यूशंस अपने लोन्स एंड एनफोर्समेंट ऑफ सिक्योरिटी इंटरेस्ट रिकवर कर सकते हैं, ठीक है। The act aims at facilitating the recovery of outstanding loans and reducing non-performing assets in the bank and financial institutions. ठीक है, the act aims at facilitating the recovery of outstanding loans and reducing non-performing assets in the bank and financial institutions. बहुत सारे आउटस्टैंडिंग ड्यूज हो जाते हैं, ठीक है, टाइम भी एक्सपायर हो गया, the borrower is not giving them, तो आउटस्टैंडिंग ड्यूज को किस तरीके से रिकवर किया जाएगा, जो एनपीएस हो गए हैं, नॉन परफॉर्मिंग असेट्स हो गए हैं, उनको किस तरीके से रिकवर किया जाएगा। द एक्ट एनकरेजेस द creation of securitization and asset reconstruction companies to manage and recover distressed assets. बहुत सारे, देखिए दो चीजें तो मेनली होती हैं। If some of you must have read commerce in your 11th and 12th, and you must have read about assets and liabilities. There are two major distributions with regard in every firm. Like that is one is the asset, the other is the liability. Asset is what you gain profit from, and liability is a responsibility, is a due that you have to pay. So there are non-performing assets as well. There are some assets that they are generating the profit continuously. Okay, there are some liabilities that you are paying off continuously. That process is in continuation 24 hours. Assets, some of the assets, they become non-performing assets. For example, loan that you have given to somebody. Like for example, A as a financial institution has lent some money to B, and B is the borrower. So this loan which A has given to B is now an asset. It is not a liability. It is a liability on the shoulders of the B. If B is a firm, then B is going to list this loan in the liabilities column, while A, who has lent this loan to B, is going to list this in the assets column, because this loan is going to come back with an interest rate. So the bank is going to, or A is going to earn some profit on whatever it has lent to B. So this is an asset. The loan that they have given to B is an asset for the A, because in due time it is going to come back with interest rate, with some profit. So that is how it should be seen. Okay. Now, non-performing assets, for example, if the loan is not coming back, or it becomes outstanding due, and if it the borrower becomes insolvent, then these are the NPAs. How to recover these NPAs? Recover the distressed assets. Some of the assets are distressed. Either they are because of they are continuously depreciating. Their values are continuously depreciating. That is one of the reasons that the assets can become over the time distressed assets. So how to recover and how to cope up with these kinds of financial losses which are every day happening. Okay. So it provides a legal framework to recover the loan amount due. That's very simple. To reduce the time and cost of recovery of secured assets. There are some secured assets also. So how to recover them? If you read company law, you will come to know there is a lot of established procedure for example, if you are an unsecured creditor or if you are a debtor, everything for your security is mentioned in the law. Okay, key provisions of the Sarfaesi Act. Section 13(2) and 13(4) are the key provisions of the Act which lay down the procedures for the enforcement of security. Okay, for the enforcement of security interest by banks and financial institutions to take possession of secured assets upon default by the borrower. See, these are the key provisions. Section 13(2) and 13(4). They are the key provisions of the Act which lay down the procedures for the enforcement of security interest by banks and financial institutions to take possession of secured assets upon default by the borrower. The process involves issuing demand notice to the borrower, providing with the sale or auction of the assets. Demand notice under Section 13(2). The Sarfaesi Act empowers banks and financial institutions to issue a notice to the borrower in case of default in repayment of any secured loan. The notice should specify the outstanding dues and demand repayment. See, the Sarfaesi Act, what does Section 13(2) says? Demand notice. If you are demanding your loan back, then it empowers the banks and financial institutions to first issue a notice to the borrower in case of default in repayment of any secured loan, that your time has become overdue, your repayment of loan has become overdue, and it's now the right time for you to at least even beyond the mature time for you to pay back the money. So first of all, notice has to be served. The notice should specify the outstanding dues and demand repayment within 60 days. So 60 days time is there. The borrower has the right to make representation against the notice before the secured creditor. And the borrower, what he has to do, the borrower has the right to make representation against the notice before the secured creditor. Like before, within a period of 60 days, he has to make a secured representation that these are the things. He has to at least reply back. This representation is before the secured creditor does not mean that he has to physically appear before the secured creditor, because secured creditor is not a judicial or a quasi-judicial authority. Physical appearance is not required. He has to reply it through a notice. Okay. If the borrower fails to comply with the notice, the bank or financial institution can proceed with the enforcement of security interest without any further notice. And if this period of 60 days expires and he fails to reply or he fails to repay the loan back, then in that case, the banks, the financial institution can move ahead and they can encash the security interest, whatever has been mortgaged upon with such bank or financial institution. Possession notice under Section 13(4). Notice issued by the secured creditor, usually bank or financial institution, to the borrower who has defaulted on their loan payments. This section pertains to the right of the secured creditor to take possession of the secured asset after the borrower has failed to comply with the demand notice issued under Section 13(2). Now, what if the secured creditor has failed to comply with the notice? Section 13(4) says notice issued by the secured creditor usually bank or financial institutions, to the borrower who has defaulted on their loan payments. This section pertains to the right of the secured creditor to take possession of the secured asset after the borrower has failed to comply with the demand notice. If there is resistance to take possession of assets, the secured creditor can approach the district magistrate or the chief metropolitan magistrate for assistance in taking possession. Like for example, if they are if the bank or the financial institutions, they are moving ahead with in order to uh, secure the security interest. For example, घर खाली करवाना है, तो अब वो खाली नहीं कर रहे हैं, तो कहां जाएंगे फिर? डिस्ट्रिक्ट मजिस्ट्रेट के पास या चीफ मेट्रोपॉलिटन मजिस्ट्रेट के पास टू टेक द हेल्प. Now here you need to know about mainly section 13.2 and 4, 13.2 and 13.4 of the Act. Default on loan payment before a possession notice under section 13.4 is issued, the borrower must have defaulted on their loan payments. Obviously, if he has paid back, there is no point in serving any notice. Demand notice has to be served. That's what we have already read. Okay, then response to the demand notice, that is within 60 days, response to the demand notice has to be served. A possession notice under section 34 includes details about the default, the outstanding loan amount, and the intention of the secured creditor to take possession of the secured asset. For example, whatever the creditor has kept as mortgaged before the or pawned before the bank or with the bank or the financial institution, the notice, there's another notice that has to be served with regard to the recovery of the secured assets. So in that case, the default, the outstanding loan amount, and the intention of the secured creditor to take possession of the secured asset has to be mentioned in the notice. The borrower has the right to challenge the possession notice in accordance with the provisions of the Sarfaesi Act. They can make representations to the secured creditor and if necessary seek legal remedies through the debt recovery tribunal to prevent delay the possession. So there is another tribunal, debt recovery tribunal, DRT. It's a very important very important tribunal, very important thing that you must know, that tribunals are special courts, and DRT is one of those, like if you visit big cities and you will come to know in judicial field that tribunals are there. So DRT is one of the most important tribunals because it has established for recovery of debt recovery tribunal is established for recovery of secured assets or to take the possession. The secured asset in question is usually the collateral or property that was used to secure the loan. The possession notice empowers the secured creditor to take physical possession of the asset. After taking possession, the secured creditor may proceed to sell the asset through a public auction as per the Sarfaesi Act's provisions. Now, whatever the secured asset is, the bank or the financial institutions can, for example, arrange an auction program and they can auction the same property and secure the money from that auction process. Okay, section 5 to 12 of Sarfaesi Act enables banks and financial institutions to transfer their NPAs to securitization and asset reconstruction companies. These ARCs are responsible for managing and recovering distressed assets. Okay, now what is the conclusion? This act represents a crucial step in addressing the challenges associated with NPAs in the Indian banking and financial sector by providing a comprehensive legal framework for the enforcement of security interest and the recovery of dues. The Act has contributed to improved efficiency and effectiveness in asset management. While the Act has achieved significant successes, ongoing reforms and amendments are essential to address emerging issues and ensure that the recovery process remains fair and transparent. So that is all in this lecture, Sarfaesi Act. Thank you.